Welcome back to Protecting Trade Secrets. I'm Professor Seth C. Oranburg. In the previous three modules, we've focused on protection, how to identify trade secrets, assess their value, mitigate internal risks through employee agreements and training, and manage external risks through vendor controls and M&A due diligence. We've built a comprehensive framework for safeguarding confidential information before anything goes wrong. Now, in Module 6, we shift from prevention to enforcement. This is where the law moves from guidelines and best practices to courtroom battles. It's where companies must prove, not just assert, that their information qualifies as a trade secret, that someone misappropriated it, and that they're entitled to relief. And it's where defense lawyers dismantle those claims by showing that secrets weren't really secret, that acquisition was lawful, or that the plaintiff's own conduct undermined protection. This module addresses three core questions. First, in this lecture, what constitutes misappropriation under UTSA and DTSA, and how do these parallel frameworks differ in ways that matter for forum selection and remedy availability? Second, in the next lecture, when can courts issue injunctions, and what are their limits? Third, in the final lecture, how are damages calculated? When should companies seek them instead of injunctions? And how does the Calabrese-Melamed framework help counsel make strategic enforcement choices? By the end of this lecture, you'll understand that misappropriation is narrower than most clients think, that UTSA and DTSA create parallel but not identical paths to relief, and that defendants have powerful defenses grounded in lawful discovery and the plaintiff's failure to protect. Let's start with the central concept, misappropriation. Trade secret law rewards diligence, but it doesn't punish all competitive conduct. You can have the world's most valuable secret, protected by airtight contracts and military-grade cybersecurity, but if no one misappropriates it, there's no legal claim. Trade secret law doesn't create monopolies. It penalizes wrongdoing. That distinction is fundamental. Patent law gives patent holders the right to exclude everyone from making, using, or selling the patented invention, even those who discovered it independently. Trade secret law gives trade secret owners only the right to sue for misappropriation, the improper acquisition, use, or disclosure of a trade secret. Improper is the operative word. It means the defendant crossed a line through theft, breach of duty, deception, or inducement of breach. It doesn't mean the defendant learned something valuable or gained a competitive advantage. Those outcomes are only actionable if the method was wrong. This focus on conduct, rather than mere possession, creates a high bar for plaintiffs. They must prove not just that their information is secret and valuable, but that the defendant obtained or used it in a way that violates legal or ethical norms. If the defendant reverse engineered the product, independently discovered the method, or observed it in public use, there's no misappropriation, no matter how much the plaintiff wishes they'd kept it secret. Most trade secret litigation in the United States proceeds under two statutes: the Uniform Trade Secrets Act, UTSA, adopted by 48 states, and the Defend Trade Secrets Act, DTSA, the federal statute enacted in 2016. These statutes define misappropriation in nearly identical terms. Both prohibit acquisition by improper means, unauthorized use, and unauthorized disclosure. Both require that the information qualify as a trade secret under the three-element test we covered in Module 2. Information, independent economic value from secrecy, and reasonable efforts to maintain that secrecy. But they diverge in ways that shape litigation strategy, remedy availability, and procedural dynamics. Jurisdiction is the first major difference. UTSA claims are brought in state court under state law. DTSA claims are brought in federal court under federal question jurisdiction, 28 U.S.C. section 1331, no diversity requirement, no amount in controversy threshold. That means a plaintiff can get into federal court with a DTSA claim even if the parties are from the same state and the damages are modest. Why does this matter? Federal courts offer different procedural advantages: nationwide service of process, more predictable discovery rules, and judges with experience handling complex commercial disputes. Some plaintiffs prefer federal forums because they believe state courts are more unpredictable or more sympathetic to local defendants. Others prefer state courts because they know the local judges and juries. The key point is that DTSA doesn't replace UTSA, it supplements it. 18 U.S.C. Section 1838 explicitly states that DTSA shall not be construed to preempt or displace any other remedies available under state law. That means plaintiffs can, and routinely do, plead both UTSA and DTSA claims in the same complaint, filed in federal court. If they win, they can recover under either theory, but not double damages for the same conduct. Interstate commerce requirement is the second difference. The DTSA applies only to trade secrets that relate to a product or service used in, or intended for use in, interstate or foreign commerce. 18 U.S.C. Section 1836, subsection B, paragraph 1. This is a broad standard. Courts have interpreted it to cover nearly any trade secret with economic value beyond a single state. But it's not universal. A purely local business with no interstate connections might fall outside DTSA coverage. UTSA has no such requirement. State law protects trade secrets regardless of whether they cross state lines. For a small regional company, UTSA may be the only viable claim. Whistleblower immunity is the third and perhaps most significant difference. The DTSA includes a provision, 18 U.S.C. Section 1833b, that protects individuals who disclose trade secrets to government officials, attorneys, or in sealed court filings when reporting suspected legal violations. Here's the statutory language. An individual shall not be held criminally or civilly liable under any federal or state trade secret law for the disclosure of a trade secret that A. is made in confidence to a federal, state, or local government official, either directly or indirectly, or to an attorney, and done solely for the purpose of reporting or investigating a suspected violation of law, or B. is made in a complaint or other document filed in a lawsuit or other proceeding, if such filing is made under seal. This immunity fundamentally changes the employment relationship. Employees can now share confidential information, including trade secrets, with regulators, law enforcement, or whistleblower attorneys without fearing retaliation under trade secret law. And the DTSA requires employers to include notice of this immunity in any contract or policy document that governs trade secrets, 18 U.S.C. Section 1833, subsection B, paragraph 3. Failure to provide notice can eliminate the employer's ability to recover exemplary damages or attorney's fees. UTSA contains no comparable immunity. Some states have whistleblower statutes that might provide similar protection, but it's not uniform. The DTSA provision is clearer, broader, and federally mandated. The upshot: employee non-disclosure agreements must now include DTSA whistleblower language. If you're drafting confidentiality agreements post-2016 and you don't include it, you're inviting problems. Both UTSA and DTSA define misappropriation as three distinct acts: acquisition by improper means, improper use, and improper disclosure. A plaintiff doesn't have to prove all three. Any one is sufficient. But understanding each helps clarify what conduct crosses the line. Acquisition by improper means is the most straightforward form of misappropriation. It includes theft, bribery, misrepresentation, breach or inducement of breach of duty, and espionage through electronic or other means. UTSA Section 1, Paragraph 2, 18 U.S.C. Section 1839, Paragraph 6. The classic case is A. du Pont de Nemours and Company versus Christopher, a 1970 Fifth Circuit decision. DuPont was building a chemical plant with a partially open roof. The defendants hired a pilot to take aerial photographs to discover DuPont's manufacturing process. The court held that this was improper acquisition, industrial espionage, even though the defendants didn't trespass or hack systems. They circumvented DuPont's reasonable security measures through deliberate surveillance. The DuPont case establishes a key principle. Improper means isn't limited to illegal acts. It includes conduct that violates the norms of honest commercial behavior. Flying a spy plane over a construction site might not be criminal trespass, but it's improper acquisition under trade secret law. Other examples include hacking into a competitor's database, bribing an employee to leak documents, posing as a customer to extract proprietary pricing, or inducing a vendor to breach their NDA. In each case, the defendant targeted the secret and used deceptive or wrongful methods to obtain it. Improper use occurs when someone who has lawful access to a trade secret uses it in ways that exceed the scope of authorization. This often arises in employment and collaboration contexts. In 3M Company versus Pribyl, a 2001 Seventh Circuit case, several former 3M employees left to form a competing plastics company. While at 3M, they had legitimate access to technical manuals detailing resin formulations and production methods. But once they left, they used those same methods at their new company. The court held that this was improper use. Even though acquisition was lawful, the application of the knowledge violated their confidentiality obligations. The key insight: trade secret protection follows the information. It's not just about how you got it, it's about what you do with it. If you learn a secret under a duty of confidentiality, express or implied, using it to compete violates that duty. Improper disclosure is the act of sharing a trade secret with unauthorized third parties. It doesn't require that the defendant benefit personally or use the information themselves. The wrong lies in breaking the expectation of confidentiality. In MicroStrategy, Incorporated versus Business Objects, a 2004 Eastern District of Virginia case, MicroStrategy alleged that former employees disclosed internal competitive analysis documents to business objects in violation of their non-disclosure agreements. The court found that even though the employees had proper access while at MicroStrategy, their disclosure to a third party after departure was misappropriation. The information was shared under a duty to keep it secret, and that duty survived employment. Improper disclosure is particularly damaging because it multiplies exposure. Once a secret is shared, legal remedies may exist, but practical containment becomes nearly impossible. Defendants in trade secret cases don't just challenge whether the information is secret or whether they obtained it. They argue that even if both are true, the acquisition was lawful, and therefore not misappropriation. The two most powerful defenses are reverse engineering and independent discovery. Reverse engineering means purchasing a product on the open market, disassembling it, and analyzing how it works. This is explicitly permitted under both UTSA and DTSA. If a competitor can figure out your secret by studying your product, trade secret law provides no remedy. In Bonito Boats Incorporated versus Thundercraft Boats, a 1989 Supreme Court case, Florida tried to ban copying of boat hull designs. The court struck down the law, holding that reverse engineering is a fundamental right in a competitive economy. States can't create perpetual monopolies by prohibiting lawful analysis. The policy rationale is clear. Trade secret law protects secrecy, not innovation. If you sell a product publicly and someone can deduce your method by examining it, you've chosen the wrong form of IP protection. You should have patented it or kept it off the market. Some companies try to prevent reverse engineering through contracts, shrink-wrap licenses, terms of service, or sale agreements that prohibit disassembly. Courts have split on whether those restrictions are enforceable. But absent a valid contractual bar, reverse engineering is fair game. Independent discovery is the second complete defense. If a competitor develops the same knowledge on their own, through their own R&D, trial and error, or brilliant insight, there's no misappropriation, even if the result is identical to your trade secret. Winston Research Corp. Versus Minnesota Mining and Manufacturing Co., a 1965 Ninth Circuit case, is the landmark decision. Winston developed a product similar to 3M's design. 3M sued, alleging that Winston must have stolen the technology. Winston produced documentation showing its own engineering process, independent of 3M. The Ninth Circuit held that honest independent discovery is not misappropriation, even if the results are indistinguishable. This defense underscores the fragility of trade secrets. You can't stop someone from figuring out what you know, only from stealing it or breaching a duty. That's why trade secrets work best for information that's hard to discover independently and hard to reverse engineer. No reasonable efforts is a third defense, and it's devastating when it succeeds. Even if the defendant improperly acquired the information, if the plaintiff didn't treat it as secret, There's no trade secret to protect. In Enclosures Incorporated versus Block and Company, a 2014 Seventh Circuit case, Enclosures developed a metal iPad case and shared designs with a manufacturer under an NDA. But the company publicly showcased the designs, shared them widely without additional controls, and failed to mark materials as confidential. The court held that having an NDA isn't enough when actual conduct doesn't reinforce secrecy. By treating the design as public information, Enclosures destroyed its own claim. The lesson: reasonable efforts aren't optional, they're a threshold requirement. If you fail to protect, you can't enforce. Even when liability is clear in theory, trade secret cases often collapse due to evidentiary problems. Missing documentation is the most common. Plaintiffs must prove what the trade secret was, when it was created, who had access, and what efforts were taken to protect it. If there are no written policies, no training records, no access logs, and no marked documents, the plaintiff's case becomes a credibility contest, and courts are skeptical. Inconsistent enforcement undermines claims. If the company enforced non-disclosure agreements against some employees but not others, or responded to some breaches but ignored others, defendants will argue that the company didn't truly value the information. Delay in response is another red flag. If the plaintiff discovered the misappropriation months or years ago but waited to file suit, courts question whether the harm was really irreparable. Laches, unreasonable delay, can bar injunctive relief entirely. The takeaway: enforcement begins with documentation. Every step you took to protect the secret, every NDA signed, every training session conducted, every access control implemented becomes evidence. If you can't prove you protected it, you can't prove it was a secret. Let's recap. Misappropriation is the legal threshold for trade secret enforcement. It requires improper acquisition, use, or disclosure, not just possession of valuable information. Defendants who reverse engineer products, independently discover methods, or observe public use commit no wrong. UTSA and DTSA define misappropriation in nearly identical terms, but they diverge in jurisdiction, state versus federal. Coverage: UTSA has no interstate commerce requirement, and protections: DTSA includes whistleblower immunity and requires notice in employee contracts. The three acts of misappropriation are acquisition by improper means, theft, espionage, inducement of breach, improper use, exceeding authorized scope, and improper disclosure, sharing with unauthorized third parties. Defenses that destroy claims include reverse engineering, independent discovery, and failure to maintain reasonable efforts. These defenses shift focus from the defendant's conduct to the plaintiff's diligence. Evidentiary gaps, missing documentation, inconsistent enforcement, delay often determine outcomes. Courts expect plaintiffs to prove not just that secrets existed, but that they were systematically protected. In our next lecture, we'll turn to injunctive relief, when courts will stop ongoing misappropriation, what injunctions can and can't do, and why the DTSA's ex parte seizure remedy is both powerful and dangerous. Thanks for listening. See you in the next lecture.